Hello everyone, welcome to Master Stage. And today we are going to discuss about the fundamentals of companies law, okay, and which is very important for those who are preparing for the LLB examination across India, and which will be I'm going to discuss point like understanding the core principles of starting the company, okay, formation, governance, and regulatory compliance in modern business. Okay, let us start. What is promoters? Promoters, the individual who get the idea in order to form the company and take the necessary initiatives to bring into existence of the company. Okay, so the key functions are the promoters, the person who start the business, like they have the key functions like they identify the business opportunity, and they will arrange like finance, like location and human resources, material, buildings, ever, etc. Then legal position. So it is a fiduciary relationship with the company. Okay, they have the legal relationship with the company. Okay, so this is the thing about the promoters and their role. Then there are important documents are there. One of the document called, it is Memorandum of Association. So the first thing in this particular document, it consists of a name clause where they select the company's name, okay, with the register of companies. Okay, so the company, if it is a public limited company, it is ending with a limited. If it is private limited company, ending with a private limited. Then register office. So in memorandum of association, they decide in which jurisdiction, in which area it is going to be operate the uh, office, that is a register office. And object clause, that means they are going to define the scope of the company, objective of the company, what they are going to produce, what they are going to do, services, etc., which will be mentioned in the memorandum of association. Then another clause which states about the authorized share capital and the structures. So this is mentioned in the memorandum of association. This is the primary documents, okay, which is going to be submitted with the register of the company. Then here one more concept, doctrine of ultra virus. Okay, as I said, uh, see the core principles, objectives, and motive of the company mentioned in the memorandum of association. Okay, so if it is cross that particular limits, that become called as doctrine of ultra virus. Okay, that means acts behind the objectives. Okay, if the whatever the acts is mentioned in the memorandum of association, then that become ultra virus, then not ratifiable. Shareholders cannot validate it. If something is not validated in the shareholders, that is going to be a ultra virus. Then ultra virus void, such acts are void ab uh, intuit. So this is a core principle. So any act behind the powers specified in the memorandum of association is ultra virus. So behind the powers, and that is going to be void from the beginning. So in order to have the protection to the shareholders, so creditors from the unauthorized activities, these are mentioned in the art memorandum of association. Then articles of association, it is a document, it is a secondary document which mentions about the internal management of the company, its administration of the company, like number of directors, okay, number of how to manage the day-to-day company. Okay, that is mentioned in the articles of association. Then it is a subordinate to memorandum of association. It is must align with the whatever mentioned in the memorandum of association. So that should be aligned, not contradict to the memorandum of association. And articles of association can be changed or amended with the special resolution subject to the legal requirement. So there are two documents. One is the Memorandum of Association, another one is Articles of Association. Okay, then we discussed about the Articles of Association now. Then Doctrine of Indoor Management. Okay, what is this? When the outsiders are dealing with the company, they are entitled to assume that internal procedure has been perfectly followed. Okay, whether the company is like dealing with the suppliers, so debtors, creditors, okay, and competitors. Okay, so they assume that everything is perfect. Okay, so this is the doctrine of indoor management. See, key benefits of that protects from third parties from irregularities in internal management that could not reasonably known about them. For example, does not know apply the if the outsider actually constitute knowledge or irregularities. Okay, if the internal management is proper or not, outsider doesn't know. So in order to maintain the honestiness or faithfulness, so this doctrine of indoor management works as a protection to the third parties or outsiders. Okay, then prospectus and compliance. Prospectus means when the company issues the shares to the public, in order to invite the people, they will give one invitation. That invitation called as prospectus. So, which is number of shares, number of debentures, and about the companies and all the stuff they are mentioned. So, civil liability, compensation for the losses due to misstatement in prospectus. The company issues the statement or invitation, the prospectus. If something is mentioned wrong, then they are going to be sued in the court. Okay, criminal liability. So, when they are issued the prospect, they should compile with the law. Okay, penalty or fraudulent or misleading information. If the misleading information is mentioned in the prospectus, okay, or fraudulent information is getting, then the criminal action will be taken against the people. Okay, then section 441. Okay, it is compounding. So mechanism for settling certain offenses with the regulator approval. Then decriminalization. So uh, recent reforms converting criminal offense into civil penalties, that is called decriminalization. Okay, then membership and pre-incorporation contracts. So pre-incorporation is done by the promoters. So the members can be acquired through subscription of the shares, transfer of the shares, and transmission of the shares. Then pre-incorporation contract made before the company started are not binding the company unless it is ratified after the incorporation. So before registration of the company, whatever contracts are made, so which is not binding the law. Okay, there's a thing, rights and liabilities of the members. So members means the shareholders. Okay, they have the right to vote and right to get the dividend. Then promoters liability, remains liable until the ratification occurs. So before registration of the company, whatever the regularities or irregularities happen, that is responsible of the promoters. Promoters means the people who start the business. So these are the membership and pre-incorporation contracts. Okay, this is the thing. Then borrowing powers and debenture charges. So after incorporation, so the board of directors can borrow within the limits specified in the articles of association. In articles of association, they mention how much directors can borrow, from which source they can borrow. If they are borrowing that limit, that is acceptable. Debentures, this is a debt. Okay, where the instruments are issued. Okay, in order to in order to like to get the capital, or in order to run the business for them, they repay the interest, then charges. So securities security interest created on company asset must be registered with the specified timeline. Okay, so borrowing powers, debentures, and charges, these are the where the amount is required, which is borrowed by the uh, directors, or okay, this is the borrowing powers, debentures, and charges. Then inside trading regulations. Inside trading means the people who are working in the company, they knows about the company, they knows what is the price sensitiveness of the shares, they knows when it is going to be up, when it's going to be happen, when it's going to take the some big leap in the company. Okay, that is a insider. So that need to be that information cannot be disclosed to the others. If it is disclosed outside, then they are liable to get the penalty. Okay, so here what is written: protecting market integrity. Inside trading involves buying and selling securities based on unpublished price sensitive information. That means, so inside trading means buying and selling the some information with the company. If they use that information for the sell purpose or selling to others, that become insider trading. So insider cannot trade the materials, non-public information. That information, the company's information cannot be shared to the others. If it is shared, then they are liable to face the uh, severe criminal as well as civil um, penalties. So, as per SEBI, Security Exchange Board of India, ensure that strict inside trading norms to ensure fair market and investor protection. So, in order to save the investors, those who are invest through shares through stock market, they uh, protected by the SEBI regulation. Okay, this is the thing inside trading and regulations. So this is a small presentation about the fundamentals of company.